Hello, this is a presentation based on English law in which I look at warranties, representations and undertakings. Nothing in this talk is detailed enough to be relied upon for the purposes of a specific contract or dispute, and professional advice based on the facts of a given case is needed. Warranties, representations and undertakings are of great importance in commercial contracts, especially share purchase agreements or SPAs. First, I'm going to look at what each of these things is. Then I'll move on to have a look at the basic principles of law which govern them and the remedies which might be available for breach of a warranty or undertaking and where a misrepresentation has induced a contract. And lastly, I'll have a look at some of the modern case law on the subject and the way in which this might influence drafting choices in commercial contracts. So first, what do these three words mean? Well, the word warranty is used in different ways in English law. First, we have the technical use of the word, in which it has a meaning which contrasts with the technical use of the word condition. When used in this sense, a warranty is a term the breach of which will entitle the innocent party to claim damages, but where the breach will not entitle that party to terminate the contract. In contrast, when used in this technical sense, a condition is a term of the contract, the breach of which not only entitles the innocent party to claim damages, but also to terminate the contract as a result of the breach. In this respect, breach of a condition gives the innocent party a remedy similar to repudiatory breach of contract. So in this example, in a contract for the sale of a bicycle, if the seller warrants that it's done less than 100 miles, and where it's a condition that it's done less than 1,000 miles, the buyer will have a damages remedy if loss can be shown in the event of a breach of either stipulation, but will only be able to terminate the contract in the event that the 1,000 mile stipulation has been breached. But this technical sense is not the only sense in which the word warranty can be used. Often in a contract it's used to describe a promise that a particular state of affairs exists or has existed. For instance, this is the sense in which it is often used in an SPA, a share purchase agreement. The word undertaking, which is commonly found in certain types of contract, including SPAs, is really much harder to pin down. The well-established technical sense of the word is where it's a commitment given by a solicitor or registered foreign lawyer, in which it's relied upon by the person to whom it's given. In these circumstances, as a matter of professional conduct, the lawyer must honour the undertaking whether or not it's supported by consideration in the manner required by the law of contract. But that's not the sense of the word in which I'm discussing the word in this presentation. The main way in which the word is used in a contractual sense is simply to describe a contractual promise, and in this sense the seller undertakes to do something means the same as the seller agrees to do something. Reading commercial contracts to see the way in which the word undertaking is used, it seems to be particularly favoured when the party in question is undertaking to cause or procure a third party to act in a particular way. But this is by no means the only way in which it's used, and there's clearly no conventional context for using the word at the moment. Quite different from the contractual promise, whether it's framed as a warranty or as an undertaking, is the representation. If a statement of fact is to give rise to consequences in the law of misrepresentation, it must be as to an existing fact or as to something which has already happened. A statement that something will happen in the future can only take effect as a contractual promise. It follows that an expression of opinion by the speaker can't in itself be an actionable misrepresentation. However, implicit in such a statement of opinion might well be the statement of existing fact that the speaker genuinely holds that opinion, and in the case of an opinion, that the maker of the statement has taken care in formulating that opinion. Well, although in principle a statement as to what will happen in the future can only take effect as a contractual promise, a statement by the speaker that he or she will act in a particular way in the future might implicitly be a statement of existing fact, namely that this represents the speaker's current intention. These days, a statement of law might also have similar consequences to a statement of fact. In order to be actionable as a misrepresentation, in the classic case, the representation will have been made before the contract, and it will at least have played a role in inducing the contract. That's the natural order of events when it comes to misrepresentation. Representation, inducement, contract, in that order. But these days it's common to find in contracts, particularly SPAs, a term within the contract stated to be a representation. This can raise puzzling timing questions about inducement or reliance. Can the representee truly claim to have been induced to enter into a contract by a representation which only takes effect when the contract is executed? One way round this conundrum is to point to the very same representation appearing in an earlier draft of the agreement. That will necessarily have been communicated before the contract is executed, and makes it logically possible to suggest that the representee relied on it, progressing to the execution stage. Another device which one sees in some contracts is a clause in which the representor acknowledges that the representee acted in reliance on the representation. Whether such a provision works, and if so, what the mechanism for its operation is looked at a bit later. We'll now move on to look at the basic principles of law which apply to each of these three things. As we've already seen, one use of the word warranty is when it's understood, as in the Sale of Goods Act, in contradistinction to the word condition. And when used in this sense, although breach of warranty and condition are alike, in that the innocent party may be entitled to claim damages, in breach of warranty cases, the innocent party is not entitled to terminate the contract. Breach of condition cases they are. When it comes to damages, they'll be calculated on the contract measure in both cases. Since there is such a marked distinction between contract terms characterised as warranties and those characterised as conditions, when drafting it's important to make clear what status is intended. One might have thought that simply to apply the word condition to the term would be enough. However, in the case of Schuler and Wickman, the House of Lords was convinced that treating the particular provision in issue in that case as a condition, entitling the innocent party to terminate the contract in the event of a relatively minor breach, was so uncommercial that an alternative meaning had to be sought. In the event, the House of Lords was satisfied that the word condition, as used in that contract, meant no more than term or stipulation. Now, at one time it was thought that all contract terms were necessarily either a condition or a warranty. However, in the Hong Kong Fur case, the Court of Appeal recognised a third category of term, the intermediate or innominate term. If a term is characterised in this way, it's not normally possible to say at the time the contract is entered into whether a breach will entitle the innocent party to terminate or not. Rather, it's not until one can see the consequences of the breach that one can know whether or not termination for the breach is possible, and it's only if the breach goes to the root of the contract that termination is possible. It now seems that the courts lean in favour of characterising terms as intermediate unless either the language used or the matrix of fact dictate a different construction, or alternatively, it's a contract that the courts have in the past held to be a condition. When it comes to damages for misrepresentation, the common law recognised only a fraudulent misrepresentation as giving rise to an entitlement to damages. This was the job done by the tort of deceit. Equity offered a completely different remedy, and that was available for all types of representation, including purely innocent ones, namely rescission. But since equity offered no remedy in damages, it followed that no damages were available for innocent or even negligent misrepresentations, either at law or in equity. However, in 1967, the Misrepresentation Act created liability for non-fraudulent misrepresentations in Section 2.1. This followed just a few years after the extraordinarily radical decision of the House of Lords in Hedley, Byrne and Heller, in which the tort of negligent misstatement, or, to put it another way, the possibility of liability in tort for pure economic loss, was acknowledged. The negligent misstatement tort, however, is markedly different from the head of liability created by the 1967 Act. Being a development of the tort of negligence, the Hedley, Byrne and Heller tort works on the basis of duty, that is, a particular duty of care or responsibility which has been assumed in relation to the type of damages which have been suffered. The statutory liability created by the 1967 Act, however, works in a wholly different way. If the initial requirements of Section 2.1 are met, then the representor will be liable to the representee unless the representor can prove the defence set out in the final part of the subsection. And here is the subsection. Where a person has entered into a contract after a misrepresentation has been made to him, so this head of statutory claim is only available to a person who has entered into a contract, by another party thereto, so the claimant and the defendant respectively must be the representee and representor, and they must both be parties to the contract, and as a result thereof he has suffered a loss, then so a loss must be suffered as a result of entering into the contract. Then, if the person making the misrepresentation would be liable to damages in respect thereof had the misrepresentation been made fraudulently, that person shall be so liable, notwithstanding that the misrepresentation was not made fraudulently. So the subsection requires us to consider a hypothetical situation, namely, would the representor have had a liability in the event that the misrepresentation had been fraudulent? If the answer is yes, then the actual representor, even though not fraudulent, will presumptively have a liability. And not just any liability, the words so liable are understood to require the fraud measure to be applied to damages under this subsection, unless the representor proves that he had reasonable ground to believe, and did believe, up to the time the contract was made, that the facts represented were true. So we can see there that the representor can avoid liability, but only if they can discharge the burden of proving that they were neither fraudulent nor negligent in making the representation. When it comes to rescission, it's important to note the effect on the contract. Suppose a contract which will last for a period of time, and suppose each of the vertical pecks on the timeline are pieces of performance required by one or other party. At some point during the life of the contract, the representee realises that they've been induced to enter into the contract by a misrepresentation, and they now wish to rescind. The key point to note is that misrepresentation strikes at formation. If a contract has been vitiated by a pre-contractual misrepresentation, then the remedy of rescission will seek to restore the parties to their pre-contract positions. So the first question is it possible to unravel the contract so as to be able to put the parties back in the position they were in before performance started? If not, then rescission is impossible, and the court will not order it. If it is possible, however, then the parties will be put back in their pre-contract positions, and the court will make, if necessary, consequential orders, sometimes called counter-restitution, to achieve that state of affairs. All this is in stark contrast where a party terminates a contract, either because the other party is in repudiatory breach, or because they've breached a provision of the condition that has the status of a condition. Here, there's no question of unravelling the contract. Since misrepresentation strikes at formation, understandably that remedy seeks to return the parties to their pre-formation state. Termination for breach is different. It simply relieves the innocent party of being tied to the contract for the future. But it leaves the contract in place up to that point, and it therefore leaves all of the pre-termination performance obligations entirely untouched, whether those are the obligations of the guilty party or the innocent party. It follows that all performance obligations arising prior to termination, whether they're the obligation of the guilty party or of the innocent party, must still be performed. As to performance obligations which would, under the terms of the contract, have arisen after the date of termination, then they do not need to be performed as such. However, When it comes to the guilty party's future obligations, they must pay damages to the innocent party to compensate for their non-performance of post-termination obligations. Returning to rescission for misrepresentation, the 1967 Act makes a change here too. Rescission is essentially a self-help remedy. Although the help of the court will be required sometimes to make necessary consequential orders, in principle the representee can rescind a contract simply by giving notice to the other party. Having done so, for instance, they can then lawfully refrain from making a payment which otherwise would have been required under the contract. However, whether a representee seeks to rescind by notice or by issuing proceedings and seeking a court order for rescission, in either case, Section 2.2 gives the court power to declare instead that the contract remains in force. In that event, the court can, if appropriate, make an award of damages in lieu of rescission. The correct approach to calculating those damages in lieu of rescission is not straightforward, and the law is in a somewhat uncertain state in this area at the moment. So, to illustrate the difference in damages between the contract measure and the tort measure, let's first imagine a seller's warranty in a share purchase agreement to the effect that the target company owns the widget. Suppose that is not correct. Well, if the buyer of the target would have had something worth £10 more in the event that it had owned the widget, then the measure of damages in contract is £10. The innocent party is entitled to be put in the position they would have been in had the warranty been true. Since a breach of an undertaking is simply a breach of a contractual promise, then the same contract measure is appropriate here too. Suppose in a share purchase agreement the seller undertakes that until completion they will procure that the target carries on business in the normal course. Well, in fact, it does not do so, with the result that the seller is in breach of the undertaking. Once again, if the buyer would have had something worth £10 more in the event that the undertaking had been complied with, then the buyer is entitled to damages of £10, because that's the amount necessary to put the buyer in the position they would have been in had the contract been honoured. These two examples can be contrasted with the position in tort. Suppose the seller had represented to the buyer that the target owned the widget, but that was not true. Since misrepresentation is a tort, the tort measure of damages has to be applied. On that measure, we must identify the amount necessary to put the buyer in the position they would have been in had the representation not been made. That requires us to ask what the buyer would have done but for the representation. Suppose first that the ownership of the widget was, in the buyer's mind, decisive in its decision to enter into the contract. They wouldn't have entered into the contract but for that representation. Well, in that case, the object of damages in tort is to put the buyer back into their pre-contract position. Well, if the contract was a bad bargain from the buyer's viewpoint, then this is likely to be more advantageous to the buyer than the contract measure. The other possibility is that the representation had no causative effect at all, because the buyer simply didn't rely on the representation. In that case, no damages should be awarded. I should say here that it's never necessary for the representee to show that the representation was the exclusive driver of their decision to enter into the contract. It's enough that it was one reason why they did. An important point that I'll look at a little later, we look at a common provision in share purchase agreements by which the seller acknowledges that the buyer is entering into the agreement on the basis of and in reliance on the representation. And later we're going to ask the question, well, does that work? And if it does work, well, why does it work? But the question we're going to turn to next is, can a particular statement be both a representation and a warranty? Well, looking at Section 1 of the Misrepresentation Act, we can certainly see that the drafter of that provision envisaged that it could. where the person has entered into a contract after a misrepresentation has been made to him and the representation has become a term of the contract, then, in certain circumstances, the contract can be rescinded. Well, plainly, that is consistent only with the notion that a statement can be both a misrepresentation and a breach of a term of the contract. Well, let's turn to the Eurovideo case. In that case, the contract in question gave the licensee the exclusive right for the, quote, first exploitation, unquote, of certain videos across German-speaking Europe. In the executed agreement, the licensor warranted that the licensee had that right. As is usual with professionally negotiated contracts, the document was preceded by drafts passing back and forth, and this warranty had featured in the earlier drafts. However, the videos had in fact already been released within German-speaking Europe, and so the licensor was immediately in breach of warranty. The problem confronting the licensee was that it was impossible to prove any quantified loss flowing from that breach of warranty. So instead, the licensee claimed that the appearance of the language of first exploitation in the travelling drafts amounted to a pre-contract representation to the same effect. Since it wasn't true, the licensee sought damages for misrepresentation. Well, the Court of Appeal accepted this submission, and it followed that the licensee was entitled to damages on the tort measure. That is to say, damages which would restore them to their pre-contract position. Since they had paid a very substantial license fee, that was a very good outcome for the licensee. I should just say in passing that the contract contained an entire agreement clause, but it doesn't seem to have played any role in the decision of the court, and indeed counsel didn't seem to think that it had any significance either. In the Invatec case, it was alleged that the management accounts of the target company, in the context of a purchase of all the shares of the target, had been fraudulently created. The executed contract contained a warranty, which was therefore breached. In that case, Mr. Justice Arnold held that the appearance of the factual statements within the warranties itself amounted to a representation which was false. He therefore said, "The warranties also amount to representations of fact as to the state of Volente on the 6th of October 2005. Invatec knew prior to signing that the agreement it was about to enter into contained those warranties. In those circumstances, I cannot see any reason in principle why Invatec cannot claim that it was induced to enter into the agreement by the representations made by those warranties so as to found a misrepresentation claim if they were false, particularly if they were fraudulently made." However, a wholly different view was taken in the later Sycamore case, another case concerning a share purchase agreement. In that case, turnover figures for the target had been accidentally inflated by the inclusion of figures which shouldn't have been there. This gave rise to a breach of one of the warranties in the SPA, but this provided an inadequate remedy for the buyer because the contract included a limitation of liability for breach of warranty. So the buyer sought to show that the factual statement within the warranty was also a representation. This cap on liability did not on its terms extend to damages for misrepresentation. The contract also contained an entire agreement clause in these terms. The written terms of the transaction documents constitute the entire understanding and constitute the whole agreement in relation to their subject matter. Each party acknowledges that it has not relied on or been induced to enter into this agreement by a representation other than those expressly set out in the transaction documents. In Sycamore, Mr. Justice Mann declined to follow Invatec. His reasoning had nothing to do with the entire agreement clause because the statement of fact, which was said to amount to a representation, was internal to the contract, and so a clause designed to prevent external statements having legal effect didn't address the alleged representations. Having explained that the terms of the warranty in Invatec was in slightly different terms, he went on to say this. However, I do not think that the difference explains the difference between my views expressed above and the determination of Mr. Justice Arnold in that case. I believe that Mr. Justice Arnold would have decided his case the same way, even if the wording were the same as that in the present case. The difference between the result in that case and in this is because, with respect, I disagree with the views of Mr. Justice Arnold. For the reasons given above, I think that there is no satisfactory answer to be given by those claiming representations to have been made to the question which has to be asked: why have the warranty provisions been inserted in the contract? The answer is to be found in Clause 5 in each case. They are there because they are warranted. There's nothing more to make them into representations. I do not think it affects the position that in the present case, as in Mr. Justice Arnold's case, the parties, and in particular the warrantors, knew what was coming because the draft had been exchanged and the terms of the contract negotiated. What the warrantors knew to be coming, or more precisely, knew they were going to be providing, was expressed to be warranties, not representations. Well, Mr. Justice Mann gave his reasons for saying that warranties of existing fact could not, without more, amount to representations in paragraph 203. 1. There is a clear distinction in law between representations and warranties, and that would be understood by the draftsman of the SPA. Representations are referred to in clause 16.3, and warranties, with a capital W, are referred to elsewhere. 2. The warranties in this case are clearly and at all times described as such, and are nowhere described as representations. 3. The words of the warranting provision, clause 5, are words of warranty, not representation. There's no reason to extend the words beyond their natural meaning. It's not enough that the subject matter of the warranty is capable of being a representation. One has to find out why those words are there. One finds that in clause 5, in clause 5, and what one finds is words of warranty, not words of representation. 5. Clause 8 of the SPA contains significant limitations on the liability under the warranties. It does not refer to representations. Idemitsu was another case concerning an SPA. Sometime after completion, the buyer discovered unexpected liabilities in the target, but the SPA contained a suit time provision that meant that the buyer was out of time for bringing a claim on the relevant warranty. The buyer therefore sought to argue that the statement of existing fact within the warranty also amounted to an actionable representation. Mr. Andrew Baker QC, sitting as a judge of the Commercial Court, adopted the same view as that of Mr. Justice Mann in Sycamore, and he refused to follow Invatec. In paragraph 30, he dealt with the suggestion that the appearance of the warranty in the execution copy of the SPA amounted to a pre-contract representation in this way. It is proposed that Schedule 4 is to be characterized as a series of statements of fact made by Sumitomo to Idemitsu, but I think it is artificial and wrong in principle to read Schedule 4 like that, as if it had an existence independent of its function in the execution copy, which was to provide content for the warranties. This is therefore a case in which Sumitomo's provision of the execution copy communicated, so far as material, no more than a willingness to give a certain set of contractual warranties in a concluded contract. And that distinguishes the case from Eurovideo. Whilst not precisely the same point, it is closely related to one of the points made by Mr. Justice Mann in Sycamore. I do not think it affects the position that in the present case, as in Mr. Justice Arnold's, the parties, and in particular the warrantors, knew what was coming because drafts had been exchanged and the terms of the contract negotiated. What the warrantors knew to be coming, or more precisely what they knew they were going to be providing, were expressed to be warranties, not representations. Summing up the point in paragraph 31, he said this: Through the SPA as signed, Sumitomo made no representation to Idemitsu by Schedule 4 because Schedule 4 was not by nature a set of statements of fact made by Sumitomo to Idemitsu, but it was the agreed means by which the parties together chose to define the content of the warranties, being certain of Sumitomo's contractual promises made under the SPA. In my judgment, Sumitomo's prior provision of, or offer to sign, or signature of the execution copy, proffering such a Schedule 4, cannot give it, Schedule 4, a different character at that stage than it was to have, and in the event did have, when the SPA was fully duly concluded on the terms of the execution copy. We now turn to a possible drafting device to get over the problems faced by the buyers in Sycamore and Idemitsu. That is, expressly to state within the contract that the warranties are also representations. An example of this can be found in one of the standard published SPA precedents. Here, the defined term warranties means the warranties and representations set out in the schedule. The clause which gives effect to that schedule states that the seller warrants and represents that each warranty is true, accurate, and not misleading. On the face of it, there's a real problem with representations which are internal to the agreement. If they don't predate the agreement, how can they have induced it? As Mr. Justice Mann put it in Sycamore at paragraph 203, there is a conceptual problem in characterizing provisions in the contract as being representations relied on in entering into the contract. The timing does not work. The normal case in misrepresentation involves the making of a representation, and as a result, the entering into of the contract. That does not work where the only representation is said to be in the contract itself. Miss Newman expressly disclaimed the relevant representations being made at any earlier time. However, he plainly thought that it's different where the internal representation is an express one, because he went on to say this. In some cases, the problem is solved by an express provision making certain contractual statements representations. In such a case, the parties have agreed as to their nature and how they should be treated. But that still doesn't account for the question of reliance. In an attempt to get over that problem, the precedent contains an acknowledgement by the seller that the buyer is entering into the agreement on the basis of and in reliance on the warranties. It's true that in the law of misrepresentation, it's not necessary for the representee to show that the representation was the sole reason why the representee entered into the contract. It's sufficient to show that it was one of the reasons. Nevertheless, it's perfectly possible in a particular case that there could be overwhelming evidence to the effect that the representation was immaterial to the buyer's decision to proceed. That could, for instance, be for extraneous commercial reasons, or it could be because other representations were on the evidence decisive, or because the buyer exclusively relied on the statements made in their capacity as warranties and not as representations. The addition of words such as "and each of them" and "as representations" and "not only as warranties" might marginally improve the buyer's position as a matter of drafting, but the deeper problem is that in such circumstances the seller's acknowledgement might simply fly in the face of reality. Is it possible for the seller in a legally effective way to acknowledge that black is white? Just before we look at that, though, it's worth noting in passing that the concept of reliance has no role to play when it comes to breach of warranty. If that which is warranted is untrue, then the buyer is entitled to damages to put it in the position it would have been in had the state of affairs as warranted been true. The question whether the warranty induced the agreement is entirely irrelevant. But returning to the express acknowledgement of reliance in the context of misrepresentation, one mechanism by which such a provision might have effect is through evidential estoppel. That is, the doctrine by which a person who has formally acknowledged that the thing is black cannot in subsequent proceedings adduce evidence that it was white. They are, in the jargon, evidentially estopped from doing so. This doctrine was employed by Lord Justice Chadwick in the E.A. Grimsted case in the context of a declaration of non-reliance within an entire agreement clause, where the buyer acknowledged that it had not relied on any representations. The buyer could be evidentially estopped from asserting in a subsequent claim for misrepresentation that they had so relied. Since this removes an essential element of the tort of misrepresentation, it follows that the seller can escape liability for the pre-contractual misrepresentation, even if the buyer did in fact rely on it. However, in the earlier case of Low and Lombank, there were established quite demanding requirements for an evidential estoppel to arise. First, the acknowledgement must be clear and unequivocal. Well, with careful drafting, that seems easy enough to achieve. Second, putting the requirements into the context of a declaration of reliance by a seller, that is to say, the context in which we are currently looking at estoppels, it must be shown that the seller intends that the buyer should act on the acknowledgement. Well, that too might be easy enough to establish in many cases, but lastly, the buyer must, on the Low and Lombank test, believe that the acknowledgement is true and must have acted upon it. In many cases, that requirement could simply defeat any evidential estoppel. However, in at least two decisions, the Court of Appeal has conjured into existence a different type of estoppel, namely that which has come to be known as a contractual estoppel. The two main decisions are PK and Springwell. The requirements for a contractual estoppel are far less demanding for the party in the position of the buyer. In the absence of fraud on the buyer's part, it seems that the estoppel will arise simply from the fact that the acknowledgement features in a contract. This is quite surprising and seems to overreach what should be achievable by contract. It disables a court from deciding a case on the evidence, perhaps the irrefutable evidence, and can compel a court to decide that black is white, that a person was induced to enter into a contract as a result of a representation in the face of overwhelming evidence to the contrary. Well, a true estoppel requires detriment on the party taking advantage of it, and that seems to be lacking from the simple contractual estoppel created in these cases. What's more, the protections established by Low and Lombank in the case of evidential estoppel are absent, and even in a case between commercial parties, there seems to be real scope for injustice, though if the seller was a consumer, of course, different rules might well come into play. A strong critic of contractual estoppel, Gerard McNeill, is of the view that it's an, quote, illegitimate species of estoppel, unquote, and a myth, and that it should be exploded by the Supreme Court at the first opportunity. Well, as Professor McNeill put it, boilerplate, that is non-reliance clauses, bear no relationship to reality and push the desire for commercial certainty to unnecessary and potentially unjust extremes. In many commercial and financial transactions, where the parties both sign up to bespoke clauses seeking to insulate their documentary contract from easy collateral attack, such provisions may well represent the reality. However, such clauses are endemic in commercial transactions more generally, and where they constituted the standard terms of one party, the courts are required to investigate the substance of claims or pre-contractual representations. These are powerful criticisms, and they might well appeal to the Court of Appeal, or indeed the Supreme Court. It therefore follows that as an attempt to get over the logical problem that a representation which is internal to a contract is too late to have induced that contract, the seller's acknowledgement of the buyer's reliance, fortified by a contractual estoppel, may not survive that attack in the Supreme Court. That's the end of this talk. Do take a look at my website for a list of lectures and courses.